Hi, my name is Brent van Staden. I'm a partner in the Corporate and Capital Markets Group here at Colin Biggers and Paisley. We recently put on a presentation for clients about recent developments that are pertinent to ASX-listed companies and have decided to move our regular written updates to our clients to a digital format. So this is the first of our digital corporate updates. So please bear with me as I get used to the medium and hope you enjoy the presentation. Just a quick summary of the issues we wanted to discuss today in around 10 to 15 minutes. Relate firstly to changes the ASX has made to Guidance Note 8 around continuous disclosure. Those changes relating to a practice the ASX calls ramping, changes to how you disclose entry into contracts with counterparties, in particular being the focus, and an ASX revision around omissions from announcements. And the final change to Guidance Note 8 is guidance around the reduction or cancellation of dividends that has moved from ASX compliance updates to a formal position in the Guidance Note. The next update to look at is just Guidance Note 19 in relation to what ASX calls performance securities, which have been a focus of theirs for some time and which are in quite common use in the small cap sector. After that, a colleague of mine will just give you a brief summary of a recent court case on the meaning of heads of agreement and what pitfalls one might encounter when using those. And we'll close out with the ASIC position on virtual meetings as it currently stands, and a note on, in a related sense, on companies signing documents in the post-2020 year following some temporary amendments that were made during COVID. So just moving straight on to the first topic with the ASX and ramping. I guess some of you might ask, what is ramping? Ramping is what the ASX describes in Guidance Note 8 as announcements that are aimed at ramping up the price of securities. They give some examples of what that constitutes, but effectively it's a bunch of announcements, or rather one or more announcements that are aimed at increasing the share price, but when scrutinized lack substance. So they give an example of a business update that's worded in an exuberant fashion, but hasn't really got any substance that hasn't already been released to the market. Others are cited in the next slide as announcements that are seeking to ride on the back of strong market sentiment in a given sector. So that often happens in relation to, for example, one mineral exploration entity might announce out of the blue that it's looking at a previously unmentioned commodity in one of its exploration projects. We've seen that in the past. Or an entity that outside of the exploration sector that enters into a material contract, but which really doesn't disclose any substance. In fact, on closer examination, the contract typically isn't material because it doesn't have any contractual guarantees of revenue or other benefits for the entity. So I guess in terms of ramping, the ASX has said that it regards it as a fairly serious matter and would suspend entities that engage in that. So it's probably quite useful to think carefully about announcements, particularly in quarterly reports or business updates that may be construed in that way. Moving to the next slide, in relation to updates to Guidance Note 8 around contracts. Previous compliance updates relating to naming counterparties has been formalised in Guidance Note 8. The upshot being that ASX expects material contracts announced to contain both a description of the counterparty and where those counterparties are not well known, a summary of the due diligence that was undertaken about financial capacity to complete. I think this follows examples in the past where fairly significant contracts have been announced with little known counterparties where ultimately the contracts have not been performed. And questions have been raised around the veracity of those contracts at the time they were announced. At the same time, and we've obviously seen this in matters we've worked on, where material contracts are announced and are subsequently terminated or don't proceed. As soon as the entity becomes aware of that, it ought to make an announcement. But there has been a practice of including those in things like quarterly reports. So the ASX has indicated that such a contract termination or not proceeding should be announced in the normal way that any material information is announced, and obviously failure to do so can lead to contravention and suspension of the entity. Moving to the next update, just omissions from announcements. I think it's really stating the obvious, but they've included further guidance that matters of fact, opinion and intention that are necessary to prevent misleading or deceiving investors should be included. It's a bit of a cryptic statement, but something to bear in mind. More importantly, they've stated the fundamental principle that you can fail to disclose by incomplete information, which I think has always been understood, but it's now formally recognised in the guidance note. They cite an example of a cancer trial being announced, but some adverse results in relation to that trial being omitted. I think it's fairly perfunctory that would constitute a breach of disclosure obligations. And then just something that's obviously quite pertinent recently was, particularly during 2020, was cancelling or reducing dividends. We advise a number of clients on scenarios where previously announced dividends were cancelled by reason of the coronavirus pandemic. The ASX has now indicated that it expects more than just statements along the lines that the board thought it prudent in the current economic climate as a justification for such an announcement and such a decision. Effectively, what they're asking is the entity to explain how it came to that decision. And in fact, the ASX may even ask for what alternatives were considered by the board before that decision was made and ask the entity to announce it. So I think the upshot there is that, as you would expect, amending or cancelling an announced dividend is taken as a serious matter. And some thought has to go into how that is articulated and disclosed to the market. Moving on to recent amendments to Guidance Note 19. The Guidance Note 19 relates to what the ASX now calls performance securities. Previously, the guidance was entitled performance shares, and the change in name indicates ASX's broader interpretation of the concept. But in terms of what is a performance security, it's what we would typically refer to as performance options, performance rights, or in some cases even performance shares. A recent addition to the definition is what's now referred to as deferred consideration, which means that an agreement, particularly in relation to acquisition of an asset in consideration for which shares or other securities are being issued, often agreements of that nature will contain a deferred scrip clause where, hitting certain milestones, additional shares or options might be issued. The ASX will now treat an acquisition agreement along those lines as a performance security that is subject to all the guidelines in the expanded Guidance Note 19. Just in terms of what Guidance Note 19 covers, by way of looking at what it excludes cash-settled performance rights. Interestingly, performance securities under an arm's length takeover bid or scheme of arrangement. And interestingly, securities issued under an employee incentive scheme and to directors were approved under Listing Rule 10. There are some interesting qualifications to the last two that I'll look at in a sec. Just in terms of very briefly what issues are at stake, there are a number of listing rules that apply. I mean, obviously the first of which would be Listing Rule 7.1 as a basic starting point. But in terms of what the guidance note regulates or talks about, they refer to base requirements, which I'll address in a sec. The key metrics that they look at in terms of whether they're appropriate are what they call appropriate and equitable numbers of performance securities and appropriate and equitable milestones. So those are the key bits of guidance that one would take account of. And then there's some guidance around when shareholder approvals, independent expert reports, and in principle guidance should be sought. And just a note on disclosure obligations also. I won't dwell on the applicable listing rules, but they are listed in the slides if you have access to those. Just in terms of the base requirements for performance securities, if you don't meet these, you're going to have to get special permission from the ASX to proceed with them. But that said, they're not particularly unusual. They ought not to be transferable. They shouldn't have voting rights. They shouldn't attract dividends. Shouldn't have rights to returns of capital or participation in winding up on new issues. So that's fairly standard, I would think. The rights to convert on a change of control is fairly common, but that number has gone up to 50% or higher now. So a 30% proportional takeover, for example, wouldn't enliven conversion rights. So that represents quite a significant change from historical practice. Just on the subject of appropriate and equitable numbers, there are a number of examples in the guidance note of what the ASX considers appropriate, but I think the takeout is that they ought to be objectively fair and reasonable, in particular having regard to the additional value that's delivered when the milestone is met. So I think that's an important standard that requires a bit more technical thought than might originally be perceived. There are a number of examples cited again in the guidance note. Speaking of objective criteria, so if, for example, there's a price hurdle, they expect that it relates to VWAP. They therefore suggest that an arbitrary price that isn't weighted would be potentially inappropriate. Expiry date, or maximum of 5 years has been set, but that's the maximum. It's not applicable across the board. Shorter periods might be applicable depending on what the type of milestone is. So as you can see, ASX has taken a fairly strident regulatory stance where they'll look at what the milestones are, how they are described, and how long ought to be given for them to be satisfied. So there's quite a bit of intuition that goes into structuring a set of performance rights now. In terms of recent clarifications in particular, milestones tied to revenue or profit ought to be normalised. Milestones tied to financial measures cannot be projected financial measures. They have to be for an historical accounting period. And unaudited financial measures are not permitted. So those are the most recent amendments that qualify the general principles I mentioned before. And generally speaking, unless exceptions apply, shareholder approval or exposition in an IPO prospectus is required. In terms of independent experts' reports being required, obviously this is quite an onerous requirement, and I think there's a rule of thumb in the latest guidance that if the performance securities represent 10% or more of the undiluted capital of the entity when they're issued, you're going to require an independent experts' report. And moreover, for non-arm's length control transactions or acquisitions, so for example, the acquisition of a mining project for scrip, typically will require an independent experts report. So that's an important both timing, cost and compliance matter to bear in mind if those are proposed to be issued. The opinion, obviously, as most IERs do, relates to whether the issue of the performance rights having regard to their number and nature is fair and reasonable to non-participating security holders. The ASX also recommends that in-principle advice be obtained, except in limited circumstances. So previously it was more ubiquitous, so they've actually limited the circumstances in which it's almost automatic to seek in-principle advice. Those requirements, or those scenarios rather, are arm's length control transactions, which is a typical market takeover bid. Ordinary course of business remuneration securities, that's an interesting one. So typically a director's incentive package ought not to attract a requirement for in-principle advice, but that said, the package must comply with the equitable numbers and equitable milestone elements of this note. So they are partially regulated, even though in-principle advice isn't necessarily required. And finally, ordinary course of business acquisition securities. So effectively non-arm's length asset acquisitions don't require in-principle advice. But bear in mind, that could still require an independent expert's report, as I mentioned before. On that note, that's the end of my quick summary of recent ASX listing rule amendments. I'll quickly hand over to my colleague Damien to talk about the recent case on heads of agreement.
Thanks, Brent. My name is Damien. I'm a senior associate in the corporate team here at Collin Biggers & Paisley, commonly working in capital markets and mergers and acquisitions. So today, I'm mentioning the decision handed down in ASSK Investments Pty Limited against AMA Group Limited. This decision is a helpful reminder that parties must take care when drafting heads of agreement so that conditions precedent actually contain obligations which are consistent with the transaction contemplated by the parties. And the heads of agreement sets out how those conditions precedent are intended to operate. So in this case, the plaintiff, ASSK, and the defendant, AMA, entered into a binding heads of agreement which contemplated the sale of a smash repairs business. Under the heads of agreement, the parties agreed to enter into business sale agreements subject to the terms and conditions that were set out in the HOA. Clause 7 of that document was headed conditions precedent, but unfortunately did not actually include any operative language as to the time within which conditions precedent were intended to be met, nor did it identify what was dependent on fulfillment of those stated conditions. For example, Clause 7B required that all necessary third-party consents, authorisations and approvals were to be obtained, including the purchaser's board approval. Upon completing due diligence of the business, the purchaser's board did not approve the purchase and sought to terminate the transaction. The seller commenced proceedings seeking specific performance or alternatively damages. In making an order for specific performance, the court held that the HOA was a commercial contract, which was to be given a business-like interpretation, having regard to the language used by the parties and the commercial circumstances. The object of the HOA was not simply an agreement for the provision of further information coupled with an option to purchase, and that was reflected in the detailed terms of the HOA. The execution of a business sale agreement was not a precondition for a binding sale, and that the condition precedent was for the entry into a BSA, not for the sale transaction to complete. A final comment held by the court was that the board approval was not necessary because the HOA only required that the parties would obtain necessary authorization and approvals, but the HOA had been executed by a director and company secretary of the purchaser, acting with the authority of its board and directors, so no further approval was required. On 29 March 2021, ASIC adopted a no-action position in relation to the convening and holding of virtual meetings. This position is intended to be a temporary measure provided by ASIC. It supports the holding of meetings using appropriate technology. It also facilitates electronic notice of meetings, including supplementary notices. However, only applies to meetings held between 21 March and the earlier of 31 October or the date that any measures are passed by Parliament. So watch this space while we wait for legislative intervention by Parliament. Our final slide is just a update or reminder on electronic execution of documents by companies. Before the COVID ministerial determinations, there was a divergence of opinion on whether electronic execution or split execution was effective under Section 127 of the Corporations Act. Justice Stanley delivered some comments in obiter in Bendigo and Australia Bank Limited against Pickard, which questioned the validity of split executions and electronic execution generally, with a expressed view that Section 127 requires officers of a company to execute a single static physical document. So the outcome of that case, in terms of adopting a conservative position to ensure that documents are validly executed, we recommend companies signing a single static document in wet ink to ensure that the document is binding under the Corporations Act.
Well, that's all we've got for our first digital corporate update, but we anticipate doing many more, and I ask you to bear with us as we refine our presentation and get a bit used to the digital medium. We hope you enjoyed it, and we'll be back soon.